she's an 18-year-old who literally kicked and beat a 14-year-old and then had the gall to post another video of it on TikTok.
Amanda Jones, an 18-year-old, allegedly assaulted a 14-year-old girl so brutally that the victim ended up curled on the ground in a fetal position. But what shocked the judge even more was what allegedly happened after.
Ms. Jones, have you heard what the attorneys have said the resolution in this case is?
Yes.
And is that how you wish to resolve it?
Yes.
Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
October 10th, 2025. Amanda is standing before Judge Hartel facing a misdemeanor assault and battery charge.
Ms. Jones, it's my understanding that the agreement today is that you will plead no contest to assault and/or assault and battery. That is a 93-day misdemeanor and/or a fine of $500, and consecutive sentencing may be imposed if the offense happened in a place of confinement.
On paper, this looked like a normal pre-trial conference. A deal was already on the table. Both attorneys had worked it out before anyone walked through the door. Routine. Except nothing about what happened on March 31st, 2025 was routine.
Now, along with that, there's what's called a Killebrew agreement. And what that is the prosecution and your attorney and you have reached an agreement that you'll be placed on a delay of sentence. And if you're successful with that delay of sentence, the case would be dismissed. Success means that you complete all the programming that your probation officer requests that you do, and you not have any violations. Do you understand that?
Yes.
The deal was built around two things: a no contest plea and a delayed sentence. Now, unless you spend time in a Michigan courtroom, those words probably just slid past you, so let us slow down.
Now, if I decide that I do not want to go along with that agreement, you have the option to withdraw your plea. Do you understand that?
Yes.
A no contest plea meant Amanda was not openly admitting guilt. She was letting the judge use the police report to accept the plea, while protecting herself from having a guilty plea used against her in a possible civil lawsuit.
Additionally, this is going to be a no contest plea due to potential civil liability. What that means is that the alleged victim in this case could potentially sue you for any damages in which she's occurred.
The delayed sentence is the other half. Under the Killebrew agreement, the prosecutor agreed to recommend probation. Amanda completes her programming, stays out of trouble, follows the conditions, and the case gets dismissed. No adult conviction, no permanent record. A clean slate in exchange for good behavior.
A no contest plea allows me to read a document, looks like it's going to be a police report, and use that police report to determine whether or not there's a factual basis to accept the plea and to use that for sentencing purposes. Do you understand that? Additionally, a no contest plea cannot be used against you. So if you are going to plead guilty and this person sued you, that guilty plea could be used against you. The no contest plea means that it's not. Essentially, you're accepting responsibility without saying that you did it. Do you understand that?
Yeah.
And is that how you wish to proceed?
Yes.
Then Judge Hartel picked up the file. He took a moment to review the report. After he read it, his entire tone changed.
I'm sorry, March 31st of this year, were you on probation or parole?
No.
Were you on bond in any other file?
No.
Then Ms. Jones, to the offense that on or about March 31st, 2025, here in the city of Cadillac of Wexford County, how do you plead to committing the offense of assault and/or assault and battery?
No contest.
Counsel, I've been provided with a Cadillac Police Department report, incident number 2500819. It's been marked as People's Exhibit number 1. Mr. Carnes, do you move for its submission?
Yes, Your Honor.
And then the video showed Amanda Jones hitting, kicking, and kneeing a 14-year-old middle schooler.
As does the court, I find the plea is knowing, voluntary, and accurate. As such, Ms. Jones, I find you guilty of assault and/or assault and battery. In particular, on March 31st, 2025, there is a video that shows Ms. Jones hitting, kicking, kneeing as the victim is lying in a fetal position by the old, what's commonly referred to as the old dam. The court can take judicial notice that is located here in the city of Cadillac.
The victim was not fighting back. She was on the ground, curled in a fetal position, trying to protect herself. She reported no physical injuries, but under Michigan law, that did not matter. Unwanted, forceful, violent touching was enough.
The victim is a 14-year-old middle schooler. The victim reported that she had no injuries. It is alleged in the police report that Ms. Jones posted another video on TikTok captioned round 2. And this appeared to be all over some things that were said about another's deceased mother. As such, I find that the elements are made out for an assault and battery, and that this would have been an unwanted, forceful, violent touching.
Then came the detail that changed everything. After the attack, Amanda allegedly went home and posted a second video to TikTok. 2 words for a caption, round 2. She filmed the attack, she posted it, she labeled it. The video showed what happened at the dam. TikTok showed the attitude. And both of them ended up sitting in front of a judge.
Mr. Carnes, are we able to sentence today?
Yes, Your Honor.
Mr. Hartel, any allocution?
Yes, thank you, Your Honor. Anytime it's no contest, especially for civil liability, I'm cautious to overly allocute for obvious reasons. But what I will say is my client has, to my knowledge, done well on bond. She stayed in constant contact with the defender's office, been very cooperative. She does have strong ties to the community. I don't doubt she'll do well on probation. She's highly motivated to do well and receive the benefit of the delay. I, in these situations, always advise my clients if they don't do well, there is the risk of jail later, the loss of delay, the public adult record. She's a relatively young adult. She wants to be able to pursue various careers and ambitions. At the moment, she's working at Qdoba. She's aware she owes some money on some older files, but she is going to, I believe, do a wage assignment, if I understand that correctly. She also has some friends with her in the courtroom who've been supportive throughout these procedures, and I don't doubt will continue to be supportive of her as well. I ask the court to uphold the guilty verdict. Thank you.
Amanda's defense attorney stood up and made the case for mercy. His client had done well on bond. She stayed in consistent contact with the defender's office. She was cooperative. She had strong community ties. She had friends in the courtroom that day. She was young, working, motivated, with future goals she wanted to protect. He told the judge she was highly aware that if probation went wrong, there was the risk of jail, the loss of the delay, a public adult record.
This is a disturbing incident involving a defendant and a 14-year-old. Clearly shows some lack of judgment, lack of maturity. However, the defendant does not have any prior convictions. I think ultimately this is a fair resolution of the file. I'd ask the court to place Ms. Jones on a delay of sentence of 2 weeks.
Then the prosecutor stood up, called the incident disturbing, said it showed a lack of judgment and a lack of maturity, and then supported the deal anyway. No prior adult convictions, fair resolution. Both sides aligned. The package was clean, the agreement was in place. Judge Hartel was not convinced.
Mr. Carnes, I know the CCH is relatively blank because she's just now 18, but there's some juvenile history, is there not?
Your Honor, I don't show that on me, and I am familiar with Ms. Jones on some other things, but not where she was the defendant. So if the court has...
Well, I'm just trying to remember. I remember seems like climbing on top of the school for the 4th of July. Were there charges on that?
She reached 18. That was resolved with a civil infraction, I believe.
was going purely off memory, Your Honor.
I'm going to be very honest with everybody. I don't plan on following this Killebrew agreement.
The judge started asking questions. Amanda's adult record looked mostly blank because she had just turned 18, but he suggested there may have been more behind it. He mentioned a possible school roof incident and another case he believed was coming before a different judge. Still, he was careful. He said he was going from memory and would not rely on anything he could not verify.
She's an 18-year-old who literally kicked and beat a 14-year-old in a fetal position on the ground because of something that was said about somebody else's deceased mother, and then had the gall to post another video of it on TikTok. That's not somebody who's making a mistake. That's not what height or this type of thing is designed for.
But he had seen enough. He told the courtroom directly. He did not plan on following the Killebrew agreement. Amanda was 18. The victim was 14 and was on the ground in a fetal position being hit, kicked, and kneed. The whole thing allegedly started over words said about someone else's deceased mother. And then Amanda went home and posted round 2.
The delay of sentences to allow the court to determine whether or not the person will be successful on a term of delay in sentence, and hopefully follow through with the plans. From what I've seen from Ms. Jones and Mr. Carnes, if you tell me that charges weren't brought, I trust you on that. But I can tell you, and I'm not using any of my prior knowledge because clearly it's not full, but I do know from my time as the elected prosecutor here and as judge, and I believe she has another case coming up that she has to be arraigned on with Judge Van Olst, because I had a conflict on that because I was the elected prosecutor when that was arose. This is not a one-time mistake. Ms. Jones has been in and out of this, whether it's this court or the probate court, or somehow tied with other events.
He said a delayed sentence is designed for someone the court believes will succeed on probation. He questioned whether Amanda fit that design. Then he said the words that ended any illusion of a quiet resolution. This is not a one-time mistake.
I'm not going to make a decision today. What I'm going to do is I'm going to set this over for sentencing, and I'll allow both parties the opportunity to do sentencing memorandums and try to convince me why I'm wrong in my thought process. But as I sit here today with the information I have, I cannot in good conscience let this just get, for all intent and purposes, swept under the rug.
Amanda did not realize that every post was another exhibit. You do not get to film a 14-year-old curled on the ground, caption it round 2, and walk out of a courtroom like nothing happened. Not if the judge is paying attention. If you think the judge made the right call, hit like, subscribe for more cases like this, and tell me in the comments what sentence you think Amanda deserved.